It has to get it out. No, still lost it. They're gonna have to say no, it's something else.
But no, then I'll forget to put back on to do that.
That's just to keep it going. All the documents are on here for everybody to use.
Great, and I downloaded a new version from Hearing Docs. I connected to the network and downloaded a new version of print this morning. So
That should match up.
they should match.
Let me double. Jump to a random page. So that, I think all I did was take out the exhibit, exhausted exhibit. Yep.
Oh, online.
Okay. I think we're gonna drive it. Yeah, I've got the time. Okay. Yeah. Yeah, we'll come back on Thursday.
Okay, let's come back from the break, please. Let's come back from the break, please. Hi, our first presentation will come from the petitioner, Mr. Knight.
Thank you, Madam Hearing Officer. Mr. Chairman, members of the commission. At this time, the department would like to call its first witness and have them sworn.
All right, this is Ms. Fulham.
Yes.
It is.
All right. Do you swear or affirm to tell the truth?
Yes.
Thank you.
Could you state your full name for the record, please?
Jennifer Fulham.
And what is your current position?
I'm a Water Resource Manager, Class 1 with the New Mexico Environment Department Groundwater Quality Bureau, and I serve as the reuse team leader.
And how long have you held that position?
As provided in my written direct technical testimony filed as NMED Exhibit 2, as the reuse team leader, I provide support and oversight for approximately 450 groundwater discharge permits, at least 95 of which have some element of effluent reuse. I serve as an expert for the regulatory oversight of above and below groundwater reuse projects. I develop policy, guidelines, templates, and regulations for the Bureau. I directly supervise between 3 and 4 full-time staff, conduct compliance inspections, and personally oversee permitting and compliance for at least 23 groundwater discharge permits.
Thank you.
Also, and I know I'm going to have to say this a lot, when folks read, they tend to speed up, and we need you to take it slowly.
It's going to be a long day for the court reporter, so do everything we can for her. Please summarize your post-high school education.
I have a Bachelor of Science degree in biology with a minor in geography from the University of New Mexico and a Master of Science degree in environmental science and management from New Mexico Highlands University.
Do you hold any certifications or have you received any additional professional training that is relevant to the proceeding before the commission today?
Yes, I have received training and obtained various certifications applicable to both my position and more specifically to this proceeding. In particular, I attended and received certification from EPA's Water Quality Standards Academy for both tribal waters as well as state waters. I have certifications from EPA on quality assurance management, data quality objectives, and quality management plans. I've also taken the state's rulemaking training as well as their records and information management training. A full list of my trainings and certifications can be found in my CV, which has been filed as NMED Exhibit 7.
Can you tell us about your work experience relevant to the proceeding before the commission today?
I have been employed with New Mexico Environment Department since July of 2007 and have held my current position with the Groundwater Quality Bureau since April of 2023. During my almost 17 years with the department, I was the Surface Water Quality Bureau's Water Quality Standards Coordinator for 6 years, the Petroleum Storage Tank Bureau's Delivery Prohibition Coordinator for 3 years, and an Environmental Scientist Specialist with the Groundwater Quality Bureau for 7 years. Prior to my work with NMED, I was the Environment Department Director for Tesuque Pueblo, a graduate research assistant at Los Alamos National Laboratory, and an environmental and GIS field technician for the Pueblo of Pewaukee. The details of my job duties can be found in my CV.
Have you authored or co-authored any articles relating to your professional training?
Yes. I was a co-author on a study published by Los Alamos National Laboratory investigating migration of polychlorinated biphenyls after the Cerro Grande fire using semi-permeable membrane devices, and was the principal investigator on a paper regarding elk habitat utilization within the lower pinyon juniper forests of Tesuque Pueblo as a means to understand potential contaminant migration. This study was published and filed with New Mexico Highlands University in partial fulfillment of my master's degree.
Have you reviewed the direct and rebuttal technical testimony as filed by the parties in this matter?
Yes,
And did you submit technical testimony and rebuttal testimony in this matter?
yes. My direct technical testimony was filed as NMED Exhibit 2, and my rebuttal testimony was filed as NMED Exhibit 176.
Do you have any changes or corrections that you would like to make to that written testimony at this time?
No,
And do you therefore adopt your pre-filed written testimony as your testimony here today?
I do.
So let's go through your testimony. What is the nature of your testimony today?
Today, I will give a brief overview of my written direct technical testimony and my written rebuttal testimony. Both include the background for proposing this supplemental rule, the structure of the proposed rule, definitions associated with reuse water sources and applications, and the administrative process pertaining to developing this proposed supplemental rule.
Okay, to start off, please provide the commission with a brief summary of the proposed rule.
Well, the department is proposing reuse regulations supplemental to the state's ground and surface water protection regulations codified in 20.6.2 NMAC. The department is proposing these supplemental regulations to be adopted as a new part 20.6.8.
And what is the intent of the proposed rule?
As provided in my written direct technical testimony, this rule accomplishes a few needs. First, it establishes a framework in which water reuse is managed in New Mexico, given the critical increase and the need for ensuring water conservation and protection. As discussed in my testimony, reuse is expanding in New Mexico. This regulation also provides the language and definitions needed for consistent and transparent implementation of discharge permits as technology and applications such as indirect and direct potable reuse expand. And finally, it provides the regulatory structure for ensuring protection of ground and surface waters as it pertains to treated produced water.
Is this rule specific to produced water?
No. As provided in the title and the objective, the proposed rule is a supplemental rule to control water contaminants specific to all wastewater reuse.
Given this rule is a supplemental rule for various types of reuse, how did the department develop the overall structure of this proposed rule?
The rule is structured in a manner that covers general sections as required in all of New Mexico's administrative code. And this is in accordance with 1.24.10 NMAC. And these include the issuing agency, the scope, statutory authority, duration, effective date, and definitions. Now, there are definitions used in this rule itself, definitions that add clarity to other definitions that are subject to be interpreted, which impacts the consistency and implementation. And finally, there are definitions that are critical for consistent and protective implementation specific to wastewater reuse. The rest of the rule, as illustrated in the department's second amended proposed rule, filed as NMED Exhibit 175, was developed to accommodate reuse for various sources of wastewater. As with many rules, there is a section that provides general provisions applicable to all reuse, and then the subsequent parts, which are focused on the various sources of treated wastewater. For this rule, the department is proposing a section for domestic wastewater, which includes Section 201 for direct and indirect potable applications, Section 300, which is reserved for industrial wastewater reuse, and that is the treated wastewater originating from industrial sources. And finally, Section 400, which outlines restrictions for produced water.
And can you briefly describe the reasoning for these sections?
As discussed in my written direct technical testimony, the state of New Mexico is at a point where supplemental reuse regulations are needed to ensure transparency and consistency with regulating the discharge applications of treated wastewater for beneficial uses. Currently, the Groundwater Quality Bureau permits discharges of treated wastewater for reuse purposes under the state's ground and surface water regulations. There are about 95 facilities with some component of reuse, a majority of which are using domestic wastewater. However, with the interest in using alternative water sources, and with the adoption of the Produced Water Act and the Water Quality Act, the addressing the application of treated produced water was time sensitive. Given there are other reuse applications already occurring in New Mexico, the opportunity to codify protections evolved organically. Given domestic wastewater applications can continue with the current regulations and guidance, the objective and focus of this first phase of the rule is to start with developing the regulatory framework. So amendments are easily referenced, requiring notices of intent for produced water demonstration projects and providing clarity on discharge prohibitions using treated produced water. Given there are general provisions that will apply to all reuse sources, the rule should have these identified as the first section following the definitions. And based on overall applicability, with domestic wastewater being the most prominent and likely the most referenced, it has been identified as the next section, Section 200. Industrial wastewater reuse, meaning the water is sourced from treated industrial sources, is the next most abundant source of reuse water in the state. So it is proposed to be reserved as Section 300. And then finally, there is the produced water section, proposed to be Section 400 of this rule. Given that the goal of the Water Quality Act is based on water protection, parsing out the rule based on the contaminants in the source water, the development of standards and regulatory protections will align with the potential risks. This structure is critical for ensuring cohesiveness with amendments, citing references, and consistent implementation.
So how is it clear that this rule is a supplemental rule for all sources of wastewater reuse?
It is provided in the title, which states it is a supplemental reuse rule, and in the objective section, where it clarifies this rule is to supplement the general requirements regarding noticing, permitting, and certifying federal permits in 20.6.2.1200 through 2201 NMAC, the general groundwater permitting requirements in 20.6.2 3000 through 3114 NMAC, and the state's surface water quality standards codified in 20.6.4 NMAC.
You state this rule is intended to supplement the permitting requirements for wastewater reuse in New Mexico as it pertains to ground and surface water protection. Can you explain why there is no content in the sections on domestic wastewater reuse and industrial water reuse, sections 200 and 300 respectively?
In short, the department regulates discharges of treated domestic wastewater for reuse purposes using the regulations in 20.6.2 NMAC and reuse guidelines, and will continue to do so until regulations specific to domestic reuse are codified. But at this time, no permittees are impacted by not having these regulations. On the same note, produced water demonstration projects and the department's authority to require notices of intent is impacted and makes this rule time sensitive for this particular industry and impacts to ground and surface water protection. More detail of my reasoning is found in NMED Exhibit 176.
Which is, as you noted, your rebuttal testimony. Is that right?
Correct.
So the development of the regulations for domestic and industrial wastewater sources is still in development.
Yes.
Would it have made sense, as indicated in D'Antonio's testimony, filed as NMOGA Exhibit 2, to wait until the language and evidence for these sections was developed before petitioning the commission?
No. The problem with that approach is that this would hold back the development of reuse regulation by years, at which point the technology and evidence for some of these sources would inevitably be outdated. Waiting years to develop the regulations for produced water would have put the department in a predicament, given the notices of intent are not required under the current regulations for non-discharging projects, and there is no clear authority to deny a permit for a produced water discharge, as Mr. Herman discusses in his testimony. Finally, it is important to clarify that almost all rules are developed in phases and amended as new science or evidence warrants. I do not know of any regulation that has not undergone amendments over time, and one can look at a part of the administrative code and see the list of amendments and their dates at the end of each section.
What makes this phased rulemaking approach more efficient?
Well, as discussed in more detail in my rebuttal to D'Antonio's testimony, there are three significant reasons for conducting rulemakings in a phased approach. First, the resources needed to develop a rule of magnitude suggested by D'Antonio would be extensive and would slow any rulemaking development by years. Second, this rule covers a broad range of wastewater sources, and water reuse is an emerging and rapidly evolving field. In this context, it is important to get an overall framework in place so that we can build on it as each area develops. Waiting until we have all the answers to propose any rule at all, and then trying to do it all at once is simply not practical. It would create risks to surface and groundwater in the meantime. The third reason for not conducting a single rulemaking is the consideration of the public and the commission's time to be able to invest in participating in the rulemaking process. Sufficient time should be afforded for everyone to review the evidence and participate in a meaningful way. Trying to conduct a comprehensive rulemaking would require an extensive amount of time, thus extending the rulemaking process out even further.
But if there are guidelines and permits already issued for domestic wastewater reuse, why is the department initiating an overall supplemental reuse rule? Why not just continue using the guidance and the regulations in 20.6.2 NMAC?
It is a good question. First, the guidelines are not subject to a public process, whereas a rule is. Second, the guidelines are limited to domestic wastewater reuse, whereas the state has the need for other types of reuse, including reuse from industrial sources and applications such as direct and indirect potable. Currently, there is a public comment period for each permit as it is issued, renewed, or modified. But if one were trying to focus on the conditions for all the permits with a reuse element, it would take years of continually scanning public notices and reviewing each permit on a case-by-case basis as it came up. This is illustrative of the growing need in New Mexico to conserve and protect our water. Essentially, we are outgrowing the 2007 guidance, and given the number of reuse permits the department is managing, the time to codify these regulations is becoming more pertinent.
As far as the topic of produced water goes, you mentioned that section 400 is titled produced water reuse. Given this is a reuse rule and produced water has its own section, does this imply that discharges of produced water, treated or untreated, would be authorized?
No. Section 400 has three subsections. The first, subsection A, is general requirements, which explicitly prohibit treated or untreated produced water discharges. Subsection B discusses authorized uses, for which this rule only authorizes non-discharging demonstration or industrial projects, pending determination by the department through the notice of intent process that the project is non-discharging. Subsection C then discusses the elements necessary for the notice of intent so that NMED can make the determination and ensure there are no discharges.
Was the intent of this phase of the rule ever to permit application of treated produced water?
No. As far back as 2019, as illustrated in public presentations submitted as NMED Exhibit 61, the intent of this first rulemaking was to be restrictive.
And does the language in the rule provide for discharges of produced water?
Again, no. The rule prohibits discharges of produced water, treated or untreated, but the department recognized that in former versions of the petitioned rule, the headers of subsection 400B was titled Authorized Applications, which could have been misleading.
Was there objection to the language in this section of the proposed rule, the section on produced water?
There was no direct objection to the language, but there were objections asserting the rule allowed for discharges of produced water, which it doesn't.
And what was the issue with using this language for the header?
So although the language within the subsection clearly discusses non-discharging uses of produced water, the title implies that applications, being defined as discharges subject to a permit, were being authorized. This may lead one to conclude that the department and this rule authorize such activities, which is directly conflicting with the language in subsection A that explicitly states the department would not certify or issue permits that discharge to ground or surface waters.
So was the language in the header for 20.6.8.400B, was that language clarified to align with the intent and other parts of the proposed rule?
Yes. As provided in NMED Exhibit 175, the header has been amended to reflect the authorized uses, which at this point only allows for non-discharging demonstration and industrial projects.
So the department is proposing these regulations to accommodate need for a clear path with protective restrictions for produced water while still implementing other reuse permits without interruption. Is that right?
Yes.
Let's talk about the definitions in the proposed rule. In your testimony about the structure of the rule, you touched upon some of the definitions for wastewater sources. Can you explain in a little more detail why the department is proposing terminology associated with wastewater reuse sources?
So, as the reuse team leader, all applications and draft groundwater discharge permits with proposed reuse are routed through me. In permits, one of the common issues we run into regularly is the use of terminology. Without defined definitions between source waters and applications, terms tend to be used interchangeably, which is problematic when you are trying to distinguish between a wastewater source and the discharge. You will commonly hear the term industrial reuse, but currently, this could be referring to the source of treated wastewater or the intended end use for industrial purposes. The need to develop consistency in terminology is critical for consistent implementation of permits and communicating those requirements with a regulated community. In order to resolve this issue, the department has proposed terms to differentiate between wastewater sources being used for reuse and the applications, which are the types of discharges.
Were there any objections to the definitions relating to source waters?
There was no direct opposition to the definition for domestic wastewater. There were some comments on the definition of produced water, but I will defer to Kathleen Murphy to discuss the merits of those objections in more detail.
Are the terms associated with reuse interchangeable with terms for applications?
No, and historically in our groundwater discharge permits, we've referred to terms on a case-by-case basis, which over time, with ever increasing number of permits, is problematic for consistent implementation and enforcement.
Are these terms currently integrated into discharge permits?
To an extent, The department does reference various types of applications and the source of treated wastewater, but consistent reference to these types of applications being used in permits varies considerably, even with efforts to streamline terminology. As provided in my written direct technical testimony, the ability to quantify volumes or discharge for our permits isn't exceptionally accurate.
Can you point out how the proposed terms associated with applications are structured in the proposed rule?
Sure. There are 12 terms related to reuse applications. The first is the broad term for application, which identifies that an application is a discharge of treated wastewater for reuse. Then there are 11 subcategories, with varying descriptions predominantly related to potential threat to groundwater and human exposure. My direct testimony goes into more detail on how each of these subcategories is relative to developing permit conditions based on the risk to groundwater and human health.
When discussing definitions for applications, why is it important to consider where the reused water goes or how it is applied? Isn't clean water good enough?
You would think. But the fact of the matter is that the impacts to ground or surface water is dependent on how the water is applied. Contaminants are harmful based on dose. So concentration and potential exposure or migration to a ground or surface water varies with each of these types of applications. In order to condition permits to be protective, we have to know what contaminants are in the source water before treatment, the type of treatment being employed, how effective it is in removing those contaminants, the quality of the treated water, and how it will be applied for reuse. This allows us to determine what types of limits on exposure and concentrations are protective. It is important to clarify that not all treated water is protective of human health or the environment. Both the source and type of application must be considered.
Were there any objections to the definitions relating to applications?
There were, particularly from Amigos Bravos and Sierra Club, as described in DeSalen's testimony, filed as ABSC Exhibit 6, although others also objected to the inclusion of definitions for various applications.
What is, as you understand it, what was the basis for these objections?
The overwhelming majority of the objections were for the specific types of applications, because the terms are not used directly in the rule. The arguments conclude that without the use in the rule, it is impossible to understand the applicability of the term.
Does the department disagree with the reasoning for those objections?
Yes. First, this rule is supplemental to 20.6.2 NMAC, which provides the language for permitting discharges. These terms are aligned directly with the enforceable language in a groundwater discharge permit. Secondly, DeSalen's argument citing the legislative style manual is misleading. This is the manual used for formatting of acts adopted by legislature. As discussed in my rebuttal testimony, it is also used for formatting and style of regulation. However, there is a critical functional difference between an act and a regulation. A regulation is the tool used for implementation. The New Mexico Administrative Code Regulation, filed as NMED Exhibit 181, does state in 1.24.10.12 NMAC that relevant portions of the legislative drafting manual should be used for style, but nowhere in this section does it discuss guidance for definitions. In addition, the regulation identifies the Administrative Law Division of the State Record Center and Archives as the delegated entity for determining if a regulation meets style and format.
And did the department submit the proposed rule to the Administrative Law Division for review?
Yes. As provided in my rebuttal testimony, the department submitted the proposed rule to state records on October 27th, 2023.
And did the Administrative Law Division provide any comments or edits?
Yes. As discussed in my written rebuttal testimony, the Director for the Administrative Law Division provided edits to the proposed rule prior to public comment. This email was filed as NMED Exhibit 183. It should be noted the Administrative Law Division did not have any edits regarding the definitions.
Are there other regulations that have definitions that are not used within the body of that particular rule?
Yes. As provided in my rebuttal testimony, there are quite a few examples. The inclusion of these definitions as proposed in this rule is not that unusual and would not be setting precedent.
Is the commission, in your opinion, authorized to adopt regulations to implement actions that protect ground and surface water?
Yes, as provided in my rebuttal testimony, I believe the commission has the ability to adopt definitions that aid in implementation. The department has the need for these definitions for implementation and permits. And given this is a supplemental rule for the already codified permitting regulations to protect ground and surface water, this is the applicable place for these definitions. And given implementation is the function of a regulation, and the Administrative Law Division did not have concern with the inclusion of these definitions as proposed, I see no reason why these definitions should not be adopted.
What would be the consequence of not adopting definitions for these terms as suggested by some of the other parties?
Well, for the already 95 plus existing groundwater discharge permits with reuse elements, having defined terms that have been subject to public participation for the types of applications is key to being able to manage the state's water resources effectively. The department could develop terminology without engagement, such as through guidance, but developing enforceable terms without engagement is not ideal because it is subject to change without having a notification process in place to notify the affected permittees or the public. Our goal is for protection of ground and surface water, and that requires knowledge and involvement from the affected parties. To be honest, the department has implemented terms for reuse as needed up until now, but the department felt that the significant increase in interest and exponential development of water reuse in the state warrants codification of these terms sooner rather than later.
Does having definitions for the various applications in the rule imply discharge of produced water is permitted?
No. And as I discussed earlier, this rule is a reuse rule. It is not a produced water rule. The scope of this rule, as proposed in NMED Exhibit 175, is applicable to persons intending to reuse wastewater. Given the scope of wastewater reuse occurring in New Mexico, predominantly from domestic wastewater sources, it is imperative to implement applications in these groundwater discharge permits in a consistent manner. As discussed throughout NMED's cumulative testimony, whether produced water is ever authorized to discharge for any of the described applications still remains to be seen.
Is there somewhere a permittee or a new regulator could go to reference these terms?
Not at the moment. There is the department's 2007 above ground use of reclaimed domestic reuse guidelines and EPA's 2012 guidelines for water reuse, which are helpful, but not completely aligned with one another.
So how does a new permit writer or a permittee know what the application in their permit allows and doesn't allow?
They would have to discuss the conditions of the permit with their technical permit writer or with the reuse team leader. Because there are various nuances to how permittees propose to reuse wastewater when applying for a groundwater discharge permit, Permit descriptions can vary considerably.
Will this terminology aid in implementation under the existing and future discharge permits with reuse elements?
Definitely. Being able to refer to a codified definition that provides the permittee with the description authorized for discharge will inevitably enhance compliance and provide the regulated community with the essential information to meet expectations for groundwater protection.
So in your opinion, there is value and applicability in codifying these terms in the rule as proposed.
Yes, these terms are critical for consistent implementation, which is the core function of a regulation.
All right, now let's briefly discuss the rule development. Going back to something you mentioned earlier, there have been several versions of the proposed rule up to the most recent version, which was filed with the department's rebuttal testimony as Exhibit 175. Can you give a brief overview of the various stages of rule development and the various iterations of the rule language?
Sure. The department started with a working draft version in September of 2023. This working draft was used to initiate discussions during the advisory committee meetings. Then, in November of 2023, the department released a public comment version, which had incorporated the applicable comments and input from the advisory committee. The commission can refer to the public comment version in NMED Exhibit 49. The department incorporated the applicable public comments into the proposed rule and petitioned for a hearing in December of 2023. The commission can refer to the comments provided during the public comment period in NMED Exhibit 70 and the December 2023 version of the proposed rule in NMED Exhibit 71. Following review during drafting testimony for the December 2023 version, the department filed an amended petition in March of 2024. This version, referenced as the first amended proposed rule, is referenced as NMED Exhibit 1 and was the reference for the department's written direct technical testimony. Now, upon reviewing testimony from other parties filed on April 15th, 2024, in accordance with the pre-hearing order, the department amended the proposed rule to either clarify language or correct grammatical errors. This version is referenced as the second amended proposed rule and was filed with the commission on May 6, 2024. This version is referenced in NMED's rebuttal testimony as NMED Exhibit 175, and this is the version being considered for adoption by the commission.
Is it standard practice to have this many iterations of a proposed rule such as you described here?
It is. In the numerous rulemakings that I've been involved in, the process is iterative and public. The changes are based on input by the department, the advisory committee, stakeholders, tribes, and the public. It is the department's opinion that these iterations, based on supportive evidence, demonstrate the public rulemaking process is working, not just for the department to implement, but for the affected regulated community that adhere to these regulations and the affected citizens that depend on the protection of ground and surface waters. I provide more detail on the reasoning in my rebuttal testimony.
You mentioned quite a few points of engagement and input from various groups that contributed to the proposed rule. Is this also summarized in your testimony?
Yes, and I will discuss this a little later when I provide more detail about the administrative process, but I do provide a detailed description of the department's engagement and the regulatory obligations for the department's actions in my written direct technical testimony.
Okay, let's go back a little bit. You discussed the reasoning for the amendments between the public comment version and the version that was filed in December of 2023. But there was an amended version filed in March 2024, which is, I guess was known as, that was the first amended proposed rule. What did the department change?
Well, there were some grammatical corrections and adjustment of where the language regarding prohibition was, but the most significant amendment was to the language in section 400, which referenced industrial applications.
Okay, why was the language as proposed in the December 2023 version problematic?
As described in my written direct technical testimony, the purpose of this proposed rule was to prohibit discharges of treated and untreated produced water because, as discussed in Ms. Murphy and Dr. Hu's testimony, the evidence just hasn't demonstrated that NMED could regulate discharges of treated produced water in a way that would be protective of ground and surface waters. The issue arises because the language in section 400 referred to an industrial application as being an authorized use. But for implementation purposes, the use of the term application is a discharge, which was contrary to the intent and the rest of the language in the section on produced water. The department recognized the language as proposed in December 2023 posed a significant implementation problem.
So how did the department address that issue?
The department revised the rule to provide clarity that applications of treated produced water have not been deemed to be protective of surface or groundwater and would not be permitted. The department acknowledges the benefit and interest in exploring the potential of produced water for industrial purposes and wanted to highlight that initiative. Instead of using the term industrial applications, which again is defined as a discharge, the department created a more descriptive, non-discharging term to align with, but be more descriptive than the term demonstration project. The department wants it to be clear there are no discharges of treated produced water authorized under these proposed regulations, but use in industrial projects, similar to demonstration projects that are designed and reviewed by the department to be of no impact to ground or surface water because they will not discharge, may be conducted. This closed that inadvertent loophole that the language in the December 2023 version caused. Now, as a consequence of amending the language in section 400, the department incorporated a new definition for industrial project.
So the first amended version from March 2024 corrected the language to align with a non-discharging rule for produced water. Now let's focus on the second amended version filed on May 6th, 2024, since this is the one, that is the version being considered today for adoption. Can you highlight the amendments that are of note from the first amended version filed with the commission on March 2023?
Certainly. First, as provided in my rebuttal testimony, the department corrected some formatting issues and citations to any reference acts as provided by State Records Center and Archives, New Mexico Oil and Gas Association, Amigos Bravos, and Sierra Club. In addition, the department also concurs with DeSalen's arguments on several points. First, that direct potable applications, as defined, did not explicitly restrict sources to domestic wastewater. As such, the department amended the definition to the term direct potable application to align with the definition for indirect potable application to be restricted to reclaimed wastewater, which is limited to domestic sources. Secondly, Amigos Bravos and Sierra Club in ABSC Exhibit 1 identify two pertinent elements needed for a notice of intent under the proposed rule. The NOI should include the concentration of water contaminants in the untreated produced water and the volume of produced water being proposed in the demonstration project. As a result of Amigos Bravos and Sierra Club's testimony, the department has amended the proposed rule to include these two elements. Finally, the Salen's arguments regarding section 400D regarding effluent quality. They were noted, and so the department is proposing to strike the subsection on produced water effluent quality in its entirety instead of reserving it. Additionally, based on Namoga's testimony, the department concurs with and is proposing to add clarifying language in the scope to identify it is only applicable to the delegations afforded to the Environment Department and not those delegated to the New Mexico Energy, Minerals, and Natural Resources Department, which also administers protections under the Ground and Surface Water Protection Regulations codified in 20.6.2 NMAC.
You mentioned subsection 400D. Can you describe the amendments that have been made regarding this part?
This part of the proposed rule has undergone considerable amendments based on input from the advisory committee, public comment, internal review, and filed testimony. In short, the department initially drafted language for this section that stated until such a time that water quality criteria based on scientifically defensible information could be adopted for discharges of produced water, the department would not approve a discharge plan. Following public comment, specifically from Renovo Resources and Western Environmental Law Center, the language was amended to be more direct, remove duplication of language in other sections, and remove assumptions of future predictions. This was the version filed in December of 2023. However, on the first amended version, the department felt the language in this subsection led to confusion that there were effluent limits. So the department removed all the language, but left the subsection reserved. Based on comments from multiple parties in their testimony, the inclusion of this subsection, now that it contains no content, is not necessary. So the department is proposing that subsection D in 20.6.8.400 be removed in its entirety.
And this change reflected in the second amended rule. This change is reflected in the second amended rule filed with the commission on May 6th. Is that correct?
Yes.
So does the lack of defined effluent standards for produced water allow for a person to discharge produced water?
No. As I describe in the structure of the rule, subsection A clearly identifies that there are no discharges of produced water authorized under this rule.
Okay, moving on to the administrative process. How long has the department been working on the development of this proposed rule?
The department began efforts for this restrictive or prohibitive rule since the amendments to the Produced Water and Water Quality Act, and that was in 2019. As discussed in my written direct technical testimony, this has been a multi-year process involving the public, oil and gas industry, non-government organizations, tribes, stakeholders, the public, and the New Mexico Produced Water Research Consortium.
What actions did the department initially take to engage the public?
Well, early on, prior to any rule development, NMED presented on the topic both with the tribes and public, as illustrated in NMED Exhibits 54 and 61 respectively. The subject matter for these initial discussions was focused on the research and rulemaking efforts that were being planned based on the 2019 amendments to the Produced Water Act and the Water Quality Act.
In your written direct technical testimony, you discuss the Produced Water Advisory Committee. Please describe who was on this committee and why.
Following the department's initial outreach efforts, and as required under the Water Quality Act, the department formed the Produced Water Advisory Committee, which, as discussed in my written direct technical testimony and illustrated in NMED Exhibit 47, was comprised of members representing oil and gas, tribes, and other interested organizations.
So there was an advisory committee for the sections of the rule focused on produced water, but was there also an advisory committee for the sections relating to direct and indirect potable feasibility studies?
No,
Could you briefly describe why not?
I would be glad to. The department, aligning with the language in the Water Quality Act, which I am paraphrasing, says the commission may adopt regulations for particular industries and establish an advisory committee comprised of persons with expertise particular to that industry. But given the limited applicability of these feasibility studies, which are not mandated by all municipalities, the department determined that the adoption of this portion of the proposed rule would not have implications to the domestic wastewater industry as a whole, and as such, did not establish an advisory committee. As I discuss in my rebuttal testimony, prior to the development of this section of the proposed rule, the department has engaged with communities that are interested in developing direct and indirect potable reuse. Future regulations relevant to potable applications would likely require development of an advisory committee prior to petitioning the commission.
So once the advisory committee provided input, what other engagement did the department conduct prior to filing the petition in this matter?
Well, again, as I discuss in more detail in my written direct technical testimony, the department also solicited stakeholders and invited tribal participation prior to any public noticing. Then, in November of 2023, the department broadly distributed the 30-day public comment period notice on the draft rule. The notice of the draft rule was distributed in English and Spanish and published in newspapers, various locations on the department's website, emailed to over 3,000 subscribers on the department's listservs, sent to 135 self-identified stakeholders, and to our state's tribes, pueblos, and nations. Comments were received via the department's public comment portal. During this 30-day public comment period, the department received comments from 24 entities encompassing a total of 429 individual comments. I provide a summary of these comments in NMED Exhibit 70, but the full set of comments has also been made available on the department's water reuse webpage. Ultimately, these comments resulted in the proposed rule that was filed with the commission in December of 2023.
And were there additional noticing requirements specific to a public hearing?
Yes. Starting on page 19 of my written direct technical testimony, I outlined the various regulatory requirements for noticing a public rulemaking hearing.
For this matter, who provided the obligatory notice of public hearing?
The department.
And can you summarize the actions the department took?
Yes. The department published the public hearing notice in English and Spanish in the State Register, the Santa Fe New Mexican, and the Albuquerque Journal, all prior to the 60-day hearing requirement. In addition, the department provided notification to the agency's district managers, posted the notice in several places on the department's website, emailed the notice to individuals subscribed to the Groundwater Quality Bureau, Produced Water, and Surface Water Quality Bureau's listservs, posted the notice on the Sunshine Portal, and provided the notice to the Legislative Council Service. In accordance with 14-4A-4 of the Small Business Regulatory Relief Act, the department also provided notification via letter and later met with the Small Business Advisory Commission on March 13th, 2024. Finally, in accordance with the State Tribal Collaboration Act and the department's Tribal Communication and Collaboration Policy, the department provided the public hearing notice via email to tribal representatives. For more details on the noticing undertaken by the department, please refer to my written direct technical testimony and NMED exhibits 54, 60, and 72 through 80.
Were there objections to whether the obligatory hearing notice requirements were met?
Yes.
What was the basis of these objections?
Mr. Maxwell submitted comment to the department via email on March 25th, 2024, identifying that although the notification process met most of the requirements, all more than 60 days before the hearing notice had not been posted on the Water Quality Control Commission's website. Although it did appear in a different location on NMED's website, Mr. Maxwell followed up with a formal comment to the Office of Public Facilitation on March 26, 2024, reiterating the issue, and also pointed out a typographical error in the notice posted on the Sunshine portal.
Did the department correct the concerns posed by Mr. Maxwell?
Yes. The department notified the Office of Public Facilitation and submitted a correction to the Sunshine portal. Both entities responded with corrections by March 26, 2024, 48 days prior to the hearing.
In your opinion, given your experience with providing notices in other rulemakings, did the department sufficiently fulfill the expectations with respect to noticing this public hearing?
To the best of the department's abilities, yes.
Did the department file its notice of intent as prescribed in the pre-hearing order dated February 13th, 2024?
Yes. The department timely filed its notice of intent to present technical testimony, which included direct written testimony and supporting exhibits on April 15th, 2024.
Should the commission adopt the rule as proposed or amended, what is the process to make the rule effective for state purposes?
Well, following the determination by the commission, a final order and statement of reasons will be issued. Based on that document, the department will file the rule with state records for publication in the state register. The rule will become effective either 30 days after filing the rule with state records or after publication in the register, whichever comes later.
All right. And finally, does the department support the second amended version of the proposed rule filed as NMED Exhibit 175?
Yes.
Thank you. And that concludes this first witness's testimony. And I would at some point like to move for admission of all the exhibits, but I think I might wait until all witnesses have testified, if that's all right.
It's fine.
At this point, I would like to bring up my next witness.
All right, and I understand we're not engaging in cross-examination at this time because you're going to present your witnesses as a panel for cross.
That is correct.
All right, thank you. And if you would, we're going to have to take just a short break before public comment, which is going to begin at noon. So I'm sorry, you're only going to get about 15, 20 minutes in.
I'll try to balance speaking fast and being slow.
No.
Well, yeah,
I'll
we will
speak slowly but clearly.
we'll resume after public comment. And
That makes more sense.
Would you raise your right hand, please? Do you swear or affirm to tell the truth?
I do.
And spell your name for the transcript.
My name is Jason Herman, JASONHERMAN.
thank you, Mr. Herman. What is your current position?
I am the Pollution Prevention Section Program Manager with the New Mexico Environment Department Groundwater Quality Bureau.
And how long have you held this position?
I have been the Program Manager for 2 years.
And what duties are entailed by this position?
As the Program Manager, I oversee the permitting process for domestic, industrial, and reuse discharge permits that may affect groundwater in the state. In this position, I am responsible for managing the funding sources and grants associated with the work of the Pollution Prevention Section. And lastly, I act as the arbiter regarding implementation of the discharge permitting regulations and the enforcement as they relate to domestic, industrial, and reuse permitting.
Please summarize your post-high school education.
I have a bachelor's degree in environmental planning and design from the University of New Mexico, a master's degree in community regional planning from the University of New Mexico, and a master's degree in water resources management from also the University of New Mexico.
Can you tell us about your work experience that is relevant to the proceeding before the commission today?
Sure. Before going to UNM for my degrees, I worked for 2 companies in South Florida that focused on water treatment of all kinds. At All Florida Water, I focused on groundwater quality treatment, system design, operations of small to large treatment systems, and installations as well. One of my main duties at All Florida Water was to provide high purity water technologies and regulatory compliance for water treatment systems used for manufacturing and hemodialysis facilities, testing facilities, and microchip manufacturers. At Reverse Osmosis of South Florida, I worked on desalination of seawater for drinking water, chemical composition recreation, system design, and installation of water treatment systems for difficult or operationally difficult groundwater treatment systems. During my time at Reverse Osmosis of South Florida, I was sent to Nicaragua, Grand Bahama Island, Jamaica, and Haiti to complete repairs and installations on groundwater treatment systems, mostly reverse osmosis and ion exchange technologies. In graduate school, I worked on multiple direct and indirect potable reuse research projects, including my thesis, and as a graduate assistant on a large-scale survey related to public acceptance of potable reuse. The title of my thesis was the cost of direct and indirect potable reuse in a medium-sized arid inland community, which was followed by a willingness to pay study titled Measuring the Impact of Rate Increases on Consumer Acceptance of Potable Water Reuse Options in the Albuquerque area. At NMAD, I started as an environmental scientist in the pollution prevention section, and then was promoted to domestic waste team leader. In all, I have more than 6 years of experience in implementing the ground and surface water protection regulations at 20.6.2 NMAC. My other work experience can be found in my resume, filed as NMED Exhibit 8.
Have you authored or co-authored any articles relating to your professional training?
Yes, as I stated previously, my thesis was titled The Costs of Direct and Indirect Potable Water Reuse in a Medium-Sized Inland Community. It was published in 2017 in the Journal of Water Process Engineering. I also have 2 final reports published by the New Mexico Water Resources Research Institute. The first is the report my thesis is based on and has the same title. I won't go through it again. And the second is titled Measuring the Impact of Rate Increases on Consumer Acceptance of Potable Water Reuse in the Albuquerque area.
Have you reviewed the direct technical testimony as filed by other parties in this matter?
Yes.
And did you submit technical testimony in this matter?
Yes, my direct technical testimony was filed as NMED Exhibit 3.
Do you have any changes or corrections that you would like to make to that technical testimony?
Yes, on page 3 of my rebuttal testimony, I used the phrase, quote, to determine if a demonstration project or industrial project activities are protective of ground or surface water. That sentence should have read, to determine if a demonstration project or industrial project activities will have the potential to move directly or indirectly into ground or surface waters.
So do you adopt your pre-filed written testimony with that correction here today?
I do.
At the, can we get that information in a minute? Yeah, we'll get that to you. What is the nature of your testimony today?
My testimony will summarize the reasoning and supporting evidence the department used to draft the proposed regulations, the implications of not adopting the regulations, and how the department envisions the implementation of the proposed regulations.
All right. Can you briefly describe the sections of the proposed rule that you're covering in your testimony today?
Today, I will be testifying regarding 7 topics for the proposed regulations. First, my direct testimony covers the general authority given to constituent agencies of the WQCC that can propose regulations to the Commission. Second, my testimony focuses on multiple definitions that are used throughout the proposed regulations. Third, my testimony focuses on definitions related to domestic wastewater facilities and feasibility studies. Fourth, my testimony addresses the need and purpose of including the direct and indirect potable applications section in the proposed regulations. Fifth, my testimony provides supporting reasons and evidence related to portions of the produced water reuse section of the proposed regulations. Sixth, I will testify regarding the implementation and of the proposed regulations. And lastly, I'll testify regarding the potential consequences for not adopting the proposed regulations.
Can you briefly describe the department's reasoning for these sections?
Sure. My testimony on the authorities granted to the WQCC and constituent agencies will provide the legislative and regulatory context that the department drafted the proposed regulations within. The definitions section, as proposed, will provide the department with the necessary clarity and support to implement standardized reuse permitting as well as the proposed regulations. The proposed regulations will also explicitly prohibit the discharge of treated or untreated produced water outside the oil and gas industry. Additionally, the proposed regulations will formalize the existing process for submissions of produced water notices of intent to the department for entities that want to study produced water treatment processes in a safe and controlled manner that does not pose a threat to ground or surface waters in the state. Lastly, the proposed regulations include a section to authorize feasibility studies for communities that want to explore potable reuse options to augment their drinking water supply with treated domestic wastewater.
The first topic you mentioned is the authority of the department, the authority the department is relying on for the produced or for the proposed regulations. Can you provide a brief summary of this portion of your direct testimony?
Sure. The Water Quality Act was amended by the Produced Water Act in 2019. The Produced Water Act specifically directed the WQCC to adopt regulations to be administered by the Environment Department for many aspects of treated produced water, including the use of treated produced water outside of the oil and gas industry. The Water Quality Act already contained the guardrails and requirements necessary to promulgate regulations with directions on what the Commission should give weight to and what circumstances are relevant to the rulemaking process.
Did any party object to this section of the proposed rule?
Yes. Wild Earth Guardians, New Energy Economy, and the New Mexico Oil and Gas Association all objected to the proposed regulations on the basis that the Produced Water Act did not authorize or direct the promulgation of the proposed regulations.
And again, as you understand it, what is the basis of these objections?
The objections regarding the authority and underlying directive stemmed from a common misunderstanding of the interactions of other regulations, the proposed regulations, and the existing ground and surface water protection regulations. Some objections focused on the incorrect sections of the Water Quality Act that focus on promulgation of water quality standards instead of the appropriate sections which focus on the rulemaking process that are not related to water quality standards.
And what is the department's response to these objections?
The department believes that the proposed regulations are within the mandate in the Produced Water Act and fulfill the requirements of the appropriate Water Quality Act sections. Many of the changes suggested by the parties would exceed the department's authority and would likely be challenged in a manner that the department would be unable to defend or implement. Further, some of the suggested changes would either duplicate other existing regulations or conflict with the regulations implemented by other New Mexico state agencies and federal regulatory agencies.
What is the purpose of the proposed regulations?
Every gallon of water that is reused saves a gallon of fresh water that would normally be used for that use. This is only true if the discharged reused water is dispersed in a manner that is protective of existing surface and groundwaters as required by the Water Quality Act. The proposed regulations uphold that requirement and will ensure that produced water will not be discharged in a manner that has the potential to affect ground or surface water.
The second topic you identified earlier is the definitions used throughout the regulations and for implementation of reuse permitting. What definitions does your direct testimony address? And can you provide a brief summary of your testimony?
Yes, my direct testimony identifies 15 definitions in 3 categories, which I'll do my best to quickly list, as well as provide a short summary of the reasons for the department including them in the proposed regulations. The first category is definitions that are included by reference. Those definitions are discharge permit, discharge plan, discharge site, disposal, groundwater, and injection. The department proposes to include these definitions by reference to the controlling regulations for the proposed supplemental regulations. These definitions will assist the department in the implementation of the proposed regulations and other existing reuse permitting activities. It should be noted that discharge plan and discharge permit are used interchangeably, and in the existing ground and surface water protection regulations, different sections refer to both plans and permits due to a change in the nature of the regulations that have not yet been fully fixed. Second category is new definitions included specifically for the implementation of the proposed regulations. Those definitions are reuse water, transference, treatment, untreated wastewater, and wastewater. The department proposes to include these definitions as newly defined terms. These definitions will assist the department in implementation of the proposed regulations and other existing reuse permitting activities. The third category is definitions not found in the existing regulations, but are defined by the Water Quality Act. And those definitions are for water contaminant, water pollutant, and water pollution. The department proposed to include these definitions, which are found in the Water Quality Act. These definitions will assist the department in the implementation of the proposed regulations and other existing reuse permitting activities.
Did any party object to this section?
Yes, multiple parties objected to the definitions, including Amigos Bravos and Sierra Club's witnesses.
And what is the basis of these objections?
The major objection is that the definitions that are not used in the proposed regulations are unnecessary, confusing, or circular and should be deleted.
And what is the department's response to those objections?
In my testimony, I specifically responded only to the assertions made regarding the inclusion of definitions not used in the proposed regulations. The basis of the objections is that just because other types of documents and legislation are drafted in a certain manner, that we should always move forward with those exact methods, regardless of the situation. I do not believe that the argument that we've always done it this way is in any way the right way to innovate and move forward. The inclusion of definitions for the purpose of implementation of the regulations is a consideration that I think deserves attention. I have been in the weeds trying to make these types of regulations work, and I've often found that there to be impossible situations that could easily have been fixed by being able to point to a specific definition. I will also note that those who objected to the inclusion of these definitions have not spent any meaningful time implementing the laws and regulations they have worked on, and their perspective on the implementation reflect that experience.
The third topic you identified is the definitions related to domestic wastewater and feasibility studies. What definitions does your direct testimony address, and can you provide a brief summary of your testimony?
Yes, this portion of my testimony focuses on 7 definitions that related to direct and indirect potable reuse, domestic wastewater, and feasibility studies. The definitions all are proposed as new definitions and will assist the department in implementation of the potable reuse section of the proposed regulations. My testimony includes reasoning and evidence for the following terms: direct potable application, domestic wastewater, environmental buffer, feasibility study, indirect potable application, potable, and reclaimed wastewater.
Did any party object to this section?
Yes, multiple parties objected to most of the definitions in this category of terms, including New Energy Economy, Amigos Bravos, and Sierra Club.
And do we want to,
We do, if you just reach a good stopping.
yeah, that's as good as any.
Alrighty, thank you very much. If you would please then step away from the table. We're going to take just a very short 7-minute break. We're going to come back at noon for approximately a half hour of public comment. We will then take a lunch hour. It's just today we noticed a public comment at noon to make sure that it was outside of normal working hours. And on subsequent days, public comment around the noon hour will be taken at 1. But today we need to take a late lunch hour. So let's just take a real quick break. We'll come back and we have about a dozen public commenters. Ms. Taylor. Well, approximately, sure. All right. Any other questions? All right. Back here at noon.
Okay, still going.
Let's come back from the break, please. Ooh, pitchy. Ah, all right. We are taking a break in the technical case in order to accept public comment. This is one of many times this week that we will be inviting non-technical public comment. This is the first. There will be at least 9 more. Another one is at 5 p.m. and then we're at 1 p.m. and 5 p.m. every other day this week that the hearing is going on. So just a couple of things. One, comment is limited to 3 minutes. To the extent you have more to say than can be said in 3 minutes, please submit your comment in writing before we adjourn the hearing, which again, I hope will be later this week. You certainly have a couple of days. Please collect your thoughts. I will call on you only once because we have so much public comment to be given. And I know we had a question about making comments in Spanish. For some of the rulemakings, we have simultaneous interpreters, but a request has to have been made before today, and no request was made. However, if you have a comment to offer and would like to offer it in Spanish, please submit that comment in writing to Madai Corral or Pam Jones, again, sometime before we adjourn. The department does have someone who will translate it, a certified translator who will translate it. It will be part of the record, and the commission will be able to read that before they deliberate. Okay, just for this rulemaking, it's going to have to come in writing. All right, we have about a dozen folks who requested an opportunity to speak today. I do have a timer here, and I will ask you to honor the 3-minute limit, and I'll have to interrupt you if you approach that. And the other thing is, I will ask you, I have to swear you in, and I have to ask you to spell your name for the transcript. So let's go. We're first with Penelope Maines, and I want to pronounce people's names correctly. Please correct me if I have not done that. Do we have Ms. Maines?
Yes, yes, I'm here.
All right. Do you swear or affirm to tell the truth?
I do.
Thank you. And would you spell your names first and last?
Penelope. Last name Mainz.
Thank you very much. I'm starting the 3 minutes.
Okay. Thank you, Water Quality Control Commission. I've been a resident of New Mexico 43 years. Consideration of the draft water reuse number WQCC 23-84 reminds me of 1960 when Dr. Frances Oldham Kelsey, a new employee at our FDA, was asked to consider the approval of thalidomide for sales in the United States. Thalidomide was then widely sold in other countries for insomnia and nausea, and often to pregnant women. Believing there was insufficient evidence that thalidomide was safe for the U.S. public, Dr. Kelsey refused to approve it for use here, despite constant pressure from the company in Cincinnati, Ohio, that went into profit, and despite the fact that the drug was popular in Europe. Eventually, Germany and Australia connected the dots between thalidomide use and severe birth defects, and it was clear that Dr. Kelsey had prevented horrific tragedies in the United States. You know where I'm going with this. We don't know what toxicity and radiation could linger in produced water, even if we think we've discovered how to clean it. And we don't know what accidental spills there could occur in experimentation that would affect the population. According to the Texas Produced Water Consortium, there could be residual constituents in the produced water even after treatment, whose impacts on an intended use may not be fully known at this stage. In Wyoming, it has been reported that several sections of streams where produced water is discharged are polluted to the point they no longer support aquatic life. That is from the texastribune.org, April 29th of this year. With a nod to Dr. Kelsey, I urge the Commission to approve a very different rule. That would be that no person shall discharge, dispose of, or reuse treated or untreated produced water off of the oil field. The Department shall deny certification of any federal permit proposing to discharge, dispose of, or reuse treated or untreated produced water off the oil field. Let's remember Dr. Kelsey and her brave example. Let's put the health of our citizens before anything else, including financial or political gain. Thank you.
Thank you very much, Ms. Maines. Next is Mick Nickel. Up here.
I think that's
Please.
Michael.
Do you swear or affirm to tell the truth? Thank you. And if
I
you would
do.
state and spell your name.
Michael, Michael.
No, sir.
Swearingen.
No,
Yes?
sir. We have a Mick Nickel in the room. I didn't call on you yet.
Oh, okay. My bad.
Please go ahead, Mr. Nickel.
By the governor.
Mr. Nickel, please wrap up. Thank you, Mr. Nickel. Anna Rondon. Do we have Ms. Rondon on the platform? No? If she joins us again, I'm happy to take her comment. Annie Mattingly. Annie, oh, okay.
Hello. I do. Annie, Annie, and then Mattingly, M like in Mary, Attingley. All right. I'm a little nervous. I've never spoken roundhouse before. Thank you, first of all, for protecting our water. It's a wonderful task that you have, and I appreciate it. I think that this bill, as I understand it, undermines that role. It does not protect the water because we don't know yet enough about these, how to remove and detoxify the carcinogens and toxic chemicals and radioactivity that's in the water, in the produced water. This bill proposes to reuse this without making the water safe. And I don't understand that. I'm no expert, like the man who just spoke, but I do not understand that. My analogy is that if you're building a home, you have to start with the foundation and then the framework before you put up the roof and the walls. And I think this is working backwards, that we're trying to put the water out before we've put the foundation down, because the foundation is to determine if we can clean this water up enough so that it will not damage any of the water or land or people who are in this state. So I propose that the next thing that needs to happen is to, you can see I'm nervous. I don't usually use notes when I speak. Is it to create that framework, is to set the standards for treating. First, we have to find out if it can be treated. Then we have to find out, determine the standards, and then to monitor the treatment. That's your role, to keep us all safe. And I hope that you can do that. This is a sacred trust to protect our water, and it's been given to you. And I hope that you can honor that by not accepting this bill as it is stated now. Thank you.
Thank you, Ms. Mattingly. Lori Costello. Lori Costello? No? Ms. Costello on the platform?
Yeah, I'm online. Can you hear me?
Yes. Do you swear or affirm to tell the truth?
I do.
Right. If you would spell both of your names for the transcripts.
Lori, Lauri, Costello, Costtello.
Thank you. I'll start your 3 minutes now.
Thank you. Hello, my name is Lori Costello. I'm a physician living in Las Cruces. Please regulate the use of produced water outside oil and gas operations, and also remove demonstration and industrial uses from the legislation. In medicine, we appreciate the precautionary principle, which requires that public exposure to anything, including procedures, chemicals, and medications, demands prior proof of safety. The principle does not apply to our food or water supply or to our household products. Many for-profit corporations use the same playbook perfected by the tobacco industry. Deny the known harms, market the dangerous but profitable substance, and pay fines when necessary, since they represent only a tiny portion of already realized profits. From the beginning, wastewater has been an issue that has been ignored by the oil and gas industry, given inadequate enforcement of weak regulations. They deny the toxic chemicals in fracking fluid, even when researchers reveal them. The sheer volume of wastewater, with hundreds of known toxins, should be prohibitive. New Mexico continues to be a sacrifice zone for the fossil fuel boom that saw the Permian Basin in 2022 named the highest producing oil field on the planet, the same planet that is being destroyed by our use of fossil fuels. The PFAS chemicals that are already in most Americans' bloodstreams are endocrine disruptors that are present in fracking fluid. Since the EPA is not requiring testing and cleanup of our public water supply until 2025, fracking will continue to reap huge profits while poisoning us and the planet that used to sustain us. Please use this opportunity to prohibit further discharge of produced water, whether it is treated or not, to our surface or groundwater. Industry is also requesting a green light for demonstration and industrial uses of produced water. This is a political stunt. These uses are speculative at best and have no evidence of safety. Please redline them. Also, please strike unnecessary definitions that are not addressed in the rule. Another political stunt designed to confuse the public. The vast quantities of precious water, fresh or reused, necessary for oil and gas operations guarantees a worsening of the wastewater problem, which is already irreversible due to its sheer volume. Please prioritize the health of living beings, which are 70% water, and the health of the planet, which is also 70% water. Please protect us from the oil and gas industry's dirty, deadly secret. It's no secret at all. Thank you.
Thank you, Ms. Costello. Elaine Semino. Elaine Semino? All right, if she rejoins us.
Yes, hello?
Oh, yes, hello.
Yeah, I'm online.
All
Thank
right,
you.
thank you. Do you swear or affirm to tell the truth?
Yes, I do.
And if you would please spell your first and last name for the transcript.
ELAINE CIMINO. I'm the
Thank you. I'll
director of
start
Common
your
Ground
3
Rising and a
minutes.
resident of Rio Rancho.
Okay, thank you. I'll start your 3 minutes now.
I stand before you today to strongly oppose the fracking waste reuse rule. The proposal relies on a flawed model that has already proven disastrous. For example, a desalination demonstration project in 2007 revealed known highly contaminated raw brine. The project's waste had significant consequences, such as dumping 300 tons of TNORM radioactive waste at the municipal landfill, followed by fluid waste being dumped into the Rio Rancho wastewater system, likely ending up in the Rio Grande. The impact on our environment is invisible even from space, with the caustic water, irrigated pivot, and agricultural damage to the surrounding soil that can be seen years later. Toxic fluids from radioactive caustic wells were sprayed around the roads for dust control, exposing the public to hazardous contaminants like TNORM, radium, arsenic, and others. With approvals from NMED, this project was under a corrective action order due to its toxicity and spillage. We were denied by NMED a hearing before this board on the toxic dumping. It now appears the reason why was there was undisclosed plans to create a hazardous waste loophole. And the current proposal is a ticking time bomb, allowing for more dangerous demo projects, shifting the burden of expense of protective legal action from the health and economic harms onto communities. Instances of waste dumping on both on and off the oil field are ongoing, unchecked, including the spread of radioactive waste. We refuse to be the sacrifice for the profits of the industry. We cannot continue to rely on the industry's self-reporting or leave decisions solely to the discretion of the NMED secretary. Stronger rules are needed to protect public health and the environment, and I urge the Commission to reject this proposal and prioritize community well-being over corporate interests. Thank you very much.
Thank you, Ms. Semino. Maria McCullough? Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell your first and last name.
Maria, Maria, McCullough, McCullough.
Thank you. I'll start your 3 minutes now.
Thank you. Good afternoon. I'm here representing community members affiliated with Albuquerque Showing Up for Racial Justice, some of who are present in this room and online. I would like to affirm the importance of more public awareness about proposals that impact our water safety. I'm here to share a petition that we wrote after we learned about this proposal from an Indigenous-led partner org 1 week ago. After just a few days of circulating this petition, we've received over 50 signatures and continue to receive more, and we will submit our petition later this week. I'll read excerpts from the petition now. We add our voices in opposition to the NMED's proposed wastewater reuse rule 23-84. Repackaging toxic oil and gas waste as usable water is neither aligned with community nor environmental sustainability, as highlighted by the New Mexico No False Solutions Coalition and the Defend NM Water Campaign. We are invested in the well-being of the waters and lands we inhabit, in environmental justice and the solutions for addressing climate change. This does not include the release of wastewater that does not meet scientific-based standards for the treatment and handling of toxic and radioactive substances. Directing fracked water towards fossil-fueled hydrogen industry or other big industry efforts is sure to yield similar contamination of local communities that we have already seen with the fossil fuel industry. The fact that 38,741 instances of oil and gas spills and 616 instances of produced water spills took place in 2022 alone in the Permian demonstrates that safety is not a priority for these industries or our state's politicians. The transportation and waste disposal of fracked water will pose a huge risk to the waterways, land, aquifers, and human health of communities across New Mexico. Research by groups including the New Mexico Produced Water Research Consortium demonstrate that scientific standards and safety standards have not been created for the kind of project Governor Lujan Grisham and the NMED wish to force onto our communities. Directing $500 million towards alleged cleanup of toxic waste encourages extracting industries to continue and expand their operations. We call on the Water Quality Control Commission to follow the protections that will keep our communities' water, land, and environment safe and healthy for years to come. We call on the WQCC to oppose giving the green light for industry to poison the land through Rule 2384.
Ms. McCullough?
Thank you.
Thank you very much. Sharon Argenbright? Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell your names for the transcript.
Sharon Argenbright. Sharon, Sharon, Argenbright, Argenbright.
Thank you. I'll start your 3 minutes now.
Hello, Commission Quality Board Commissioners. My name is Sharon Argenbright. I've been a nurse for over 45 years, master's prepared in science. I taught nursing in New Mexico for 20 years to try to alleviate the nursing shortage. I've been a retired Air Force nurse, a mother, a grandmother. The nurse's job is to watch, to make assessments, Can you please make an assessment before you do this? The nurse comes up with plans, initiates the plans, and then evaluates. Can you please evaluate what you're thinking about doing? I have been paying attention. I first became aware of environmental pollution when I was 6 years old. The sky was burnt umber in color, and the stench caused watering of eyes and nasal passages. The air so malodorous, us kids driving in the car over the twin bridges of Perth Amboy, New Jersey, had to cover our mouth and hold our noses until we passed. I remembers of the oceans clouding, beach trashed with plastics watching up. I left Jersey in the 70s. I moved to LA, where I lived for 6 years before it became intolerant due to the air pollution and the suffocating air. In the military, my friend went to Iraq, and it was not long before she developed lung disease and came home to be diagnosed and died from burn pit exposure lung cancer. Of course, the etiology of all these environmental poisonings are not the same, but the impact is. I have seen enough to believe. I'm aware of the ash pit cancers and ruined lives. I'm aware of the Superfund cleanup sites. I'm aware of the Love Canals. I have seen the green cloud of methane over Farmington by satellite. I am aware of the Permian Basin catastrophe, which should be closed up, sealed, encapsulated, guarded, and cease to produce anything. The good news is this: the actual coming back up the wrong road can and does happen. I've witnessed firsthand the skies of Perth Amboy return to crystal blue, clear and fresh, and the ocean waters clearing up on the Jersey Shore. Cleanup of the oil and gas waste can happen. It will happen once oil and gas takes responsibility. Please do instead apply for federal monies for Superfund cleanup. We choose to close and seal up for perpetuity the oil and gas effluent. If and when the science leads us to it is safe, I will feel comfortable. No, I vote no to making the problem worse, no to produce water, choose life sustaining instead. Thank you very much.
Thank you, Ms. Arganbright. Destiny Ray. Do you swear or affirm to tell the truth?
Yes.
Would you spell your names for the transcript?
Destiny, Destiny, Ray, Ray. Yeah.
Thank you. I'll start your 3 minutes.
Good afternoon, esteemed chair and commissioners. My name is Destiny Ray, and I'm honored to stand before you today as a representative of YUCCO, which is Youth United for Climate Crisis Action, and as the co-chair and co-founder of Rise Youth Collective, which is resilient, inclusive, sustainable, and empowered youth. My laptop just died. Yes. Okay. As a 21-year-old New Mexico native with roots in Jemez Pueblo and the Diné Nation, as well as an African-American heritage, the protection of our water, our lands, our communities, and our health is deeply personal to me, and this rule is a threat to all of it. Today, we find ourselves at a critical juncture. A decision looms before us that will echo through the halls of history, shaping the destiny of our beloved New Mexico for generations to come. The proposed rule by the Environment Department, veiled in the disguise of industry autonomy, poses a grave threat to our very essence, our identity as stewards of this land. Let us not be swayed by the honeyed words of self-regulation and corporate oversight. Allowing industries to set their own safety guidelines for handling of toxic and radioactive wastewater is akin to handing the keys of our future to those whose interests lie solely in profit, regardless of the cost of our real well-being. Considering the staggering reality, over 1,400 oil and gas liquid spills annually with no repercussions from the agencies entrusted with safeguarding our environment. Each spill leaves a scar on our land, a stain on our conscience, and a threat to our health. Yet in the face of this grim truth, we are being asked to entertain the notion of expanding the handling, transportation, and disposal of produced water without stringent safety standards and rigorous enforcement measures in place. We cannot afford to turn a blind eye to the dangers lurking within fracking waste. PFAS, bromide, arsenic, mercury, radioactive isotopes, These are not merely chemicals. They are agents of destruction, catalysts for catastrophe. With only a fraction of these substances adequately studied for their human health impacts, we are playing a dangerous game of chance with our lives, our children's future, and the legacy we leave for generations yet unborn. As a young adult living in 2024, I am profoundly disheartened by the continual disregard for our future. I am weary of witnessing our planet, its inhabitants, and our collective well-being being sacrificed on the altar of profit. The burden we carry is not just from our own actions, but the consequences of past generations' short-sightedness. It is emotionally draining to constantly rectify messes we did not create and certainly do not deserve. But we will not wallow in despair. No, we are here to raise our voices in unison and demand accountability, to reclaim our right to clean and a healthy environment. As young people, as guardians of tomorrow, we refuse to stand idly by as our land is desecrated, our water is contaminated, and our future is endangered. We demand nothing less than a full prohibition on reusing produced water outside of the oil and gas operations and off of the oil field. Our state is not a laboratory for reckless experiment with radioactive toxic waste. Despite what industries think, we are not to be sacrificed.
Ms. Ray.
We demand action and we demand justice, and we will not relent until our voices are heard and our demands are met. Please refuse the water reuse rule. Thank you.
Thank you. And Ms. Ray, would you please email that comment to our administrator so she can get it to the court reporter? Thank you. Evelyn Bemis. Evelyn Bemis, are you online? You're there. Do you swear or affirm to tell the truth? Spell your name for the transcript.
EVALYNBEMIS.
Thank you. I'll start your 3 minutes.
Why are we here today? The obvious answer is to solve the fracking industry's problem with wastewater by commodifying it so it becomes a profit center rather than a liability. Step back from there to see the root of the problem. Towards the end of the 1990s, the world was expected to hit peak oil and needed to transition towards renewable energy. Instead, fracking technology was developed to release previously unavailable oil and gas reserves from deep underground. This method utilizes vast amounts of potable water. Suddenly, every barrel of oil or gas produced resulted in 4 to 10 barrels of poisoned water. In 2022 alone, oil and gas turned 28 billion gallons of fresh water into 86 billion gallons of toxic brew, of which the chemical and radioactive composition isn't known due to industry's claim of trade secrets protections. We don't have endless supplies of water to waste in this fashion. We don't want to solve the industry's problem by commodifying their waste and using it for agriculture or non-industrial purposes. And we don't want it anywhere near our aquifers, our wildlife, and our children. Nowhere do you see the slogan, "Oil is life." We may like the ease of putting cheap fuel in our gas tanks, heating our homes, utilizing all the plastic products made from oil. But what we really like and need is clean water to drink and bathe in, to grow food, and to nurture a healthy environment. We can live without oil and gas and must transition to renewables much more rapidly. Don't let oil and gas off the hook by allowing their poison fluids to be used outside of their own industry. Stop permitting water wells to be drained for fracking. Please stop fracking. Thank you.
Thank you, Ms. Bemis. Jennifer Grasham. Jennifer Grasham. Okay, we'll come back
I'm
to
here.
you. Oh, you are here. All right.
Yes,
Do you swear or affirm to tell the truth?
I do.
Please spell your name for the transcript.
JENNIFERGRASSHAM.
All right, I'm starting your 3 minutes.
I'm Jennifer Grasham, and I'm with the Economic Development Corporation of Lee County. The Economic Development Corporation of Lee County appreciates the opportunity to comment on the proposed new Rule 20.6.8 petitioned by the New Mexico Environment Department. Water is a precious and limited resource within our state. We are greatly aware of the need to conserve our fresh water resources. However, water is a critical resource in growing both our communities and economic viability. Our area has a surplus of non-potable and treated produced water that we could use for this purpose. The March 20th amended petition and rule will greatly hinder the economic growth and opportunities within our region and within the state. Limiting or banning the use of treated produced water limits the ability to use a byproduct of significant industry in our area for the benefit of our residents. This water can be used for many non-potable opportunities that currently depend on freshwater resources. Banning the use of these types of water forces arid communities to use precious freshwater for non-consumptive actions such as construction, road maintenance, industrial uses, instead of treated produced water, which is abundant. By switching to appropriately cleaned reuse water for non-potable uses, we conserve freshwater resources for higher needs. Several communities within the state are currently hindered by limited freshwater resources, which stunts growth in population and diversifying economies. Productive regional growth will be greatly hindered by this proposed rulemaking. Industry is rapidly growing in our area, and with this rapid growth, we have an abundance of produced water, which is currently an untapped economic resource. At the Economic Development Corporation of Lee County, we are planning for industrial and commercial growth in our area with land, governmental, and economic resources. Utilization of treated water should be one of the resources available to use. It is a key element in bringing growth through water treatment facilities, non-consumable agricultural projects, use of minerals and metals derived from the produced water, and employing the water in manufacturing and industrial uses. These economic opportunities will continue to go to Texas if we cannot offer the possibility of capturing this wealth in our state. If we do not allow reuse applications, then the communities who are wanting to engage in these ventures are forsaken of their own authority, and autonomy in policy decisions. Thank you.
Thank you very much, Ms. Grasham. Nodiah Brent. We will come back. Then we have time for one more public comment during this comment session. I didn't have anyone else on the list who reached out to Pam to say they needed to go at this time, except now Mr. So, if you would please. There are 9 more opportunities. The next opportunity is 5 p.m., but a lot of us in the room have been here for more than 4 hours, and we need a lunch break. Mr. So, do you swear or affirm to tell the truth?
Yes.
Thank you. If you would spell your name for the transcript.
DANIEL.
Thank you.
TSO. Got a Madam Hearing Officer and the panel that's seated before me. Let me, whoop, too close. Let me speak to the way the rules are currently written. What I see in my comparative analysis is what occurred with the uranium mining. Those piles fenced off when they're dry, when the wind blows, contaminates the land off the site. And how did the community members of Red Pond find out that it was affecting them? They went to butcher a sheep. All the fat and the meat was off color. So they enlisted researchers. Now we look at San Juan Generating Station. We look at Four Corners Power Plant. Something that is very light, coal ash. When it gets wet, they had to build dams. Coal ash ponds are very radioactive, and they're not good for the health and safety of those folks that live around it. So here we're looking at a small experiment that occurred in Alamogordo. But in the rules, you're saying industrial and commercial sites. That little experiment, how do you project 2,000, 3,000 times what occurred here? But this was in a controlled environment. But out there, it's uncontrolled. Sure, you can say this water, when it's put on the ground, it'll make the grass grow. Navajo people were treated as ignorant by Canales when they first approached Ohoncino chapter. Hey, we're going to put water on that, and we're going to have you be able to grow alfalfa. For every cutting of alfalfa, 12 inches of water. But at the other end of the result is we have researchers at the university, 17 major universities in the Western United States that are basically testing contamination uptake by the plants that are out there. And it's occurring. And if it happens in the Ohoncino area, you know where it's going to end up? In the digestive system and the system of the sheep and cattle that people really depend on. So in that aspect, the political science of this is that what you're trying to replicate in the control atmosphere environment, when it gets out there, it's no longer controlled. You don't apply enough to keep the soil wet, that thing's going to blow across and maybe even end up in Santa Fe. If you keep it too wet, then you have something similar to the ash ponds. Up at Nappy, we have a New Mexico State experiment station. Water from the San Juan River is used to irrigate all the fields up there. And that soil structure is so porous that it leaks out into the washes that go into Upper Fruitland. And
Mr. So, will you wrap up, please?
so in that aspect, the water testing, it has high amounts of arsenic. Now you tell me if that's going to be safe. The projects that you're selecting, you haven't even gone out to look at those sites. So I say we need a complete change in the way that you're selecting projects, a complete change in the rules that you're wanting to apply. The reason I came up is because during the hearings for the Oil and Gas Act, those of us that were plaintiffs on the constitutional lawsuit were prohibited from participating in the drafting. And so all the hearings we objected. That objection we can replicate in this particular aspect. So that's not a threat. It's just something that's going to happen all the way to the governor's office. Thank you.
Thank you, Mr. So. All right, we will adjourn for lunch at this time. We are in downtown Santa Fe, so I know there are restaurants nearby, but let's take an hour, come back at 1:45.
All right, well, gonna sit in my car for an hour and work.
Fearless leader.
If you know where the food is, I'll follow.